Clients tell me this all the time. Everything's in the trust, so we're done. Sometimes that's exactly right. Let me tell you when that doesn't always turn out to be true. Number one, the good news if everything is titled into the trust or passes by a beneficiary designation and you have a living individual who's there to collect, then there really may not be anything that is left to require probate. That's really the whole point of funding a trust properly, is so that the court administration doesn't have to kick in and take over, because that ends up being expensive and time consuming. It could just lead to some other troubles. But there are a few traps that do come up. One would be the forgotten account. So anything left in the decedent's own name is a probate asset, even if it's just one account, even if there's a relatively small amount as far as value. If it's just in that individual's name and there's no living beneficiary that was named directly or a living co-owner with survivorship rights, then the probate court has to get involved. You'll need those letters of administration and those court orders. One other note on the joint ownership is that they're not all created equal. When you look at the title ownership on an account or even more on real property, let's say on a deed, if two people or multiple people are listed as owners with rights of survivorship, then the survivor is going to take that. So if one person passes on, the remaining owner or owners just continues to own it. But if that same piece of property is owned tenancy in common, then most likely the decedent's portion still has to go through that probate. So that's something to look at carefully. The deeds can read very similarly and have very different outcomes there. Also, speaking of property, the homestead property, the decedent's primary residence, their main home here in Florida, has some special aspects to it. So sometimes a court order is needed or requested by a title company to pass title properly after somebody dies. A trust doesn't always solve that issue. And it's important to note that the trust itself is not sealed off from the decedent's debts. The assets in the revocable living trust, let's say that became irrevocable after their death, are still subject to those claims. If the estate can't pay what it owes, the personal representative can certify a demand in writing and the trustee has to pay it. So the trust can be on the hook for those types of things. And there's sometimes when a probate might make sense, even if it's not absolutely necessary. As I mentioned, you can get that nice homestead order from the court that says that property passed to particular heirs and that it's exempt from the claims of creditors. Also cuts off other claims that might be out there, like credit card debts, which may otherwise last much longer. So if you find yourself in this situation, send us a list of what's titled, where, who owns it, and we'll let you know if there's any probate necessary or anything that we can help with.